Hello, welcome to the 36th Legislative District Democrats. We are here with Justice Theo Angelis today, who is a candidate for Washington State Supreme Court. Theo, can you give us an introduction, please?
Certainly. Well, thank you. Greetings and good evening to everyone. I am the newest Washington Supreme Court Justice. Governor Ferguson appointed me in March of this year. I've been on the court now for about a month, and it has been fantastic. So, just let me give you a little bit of background of myself. I am the son of an immigrant from Greece and the grandson of refugees from Turkey. I grew up all over the country, moving around to different parishes. My father is actually a Greek Orthodox priest, and that's how we ended up in Seattle. I chose to go to law school. And when I came out of law school, I wanted to go to a law firm that really cared about social justice and would allow me to use private resources to achieve significant public results. So, one case that's notable, for example, and it's just emblematic of what I've done over the years, is that I represented an immigrant who was serving in the US military, became a naturalized citizen, was seized by ICE, held in detention for 7 months, even though he was a citizen. So I sued, was able to overcome all the defenses that the government threw at us, and we obtained a $400,000 settlement and a formal apology from the Department of Homeland Security. Um, but that's just, I've done hundreds of cases in the immigration realm, including class actions trying to get individuals representation, children representation, appointed counsel because they were forced to represent themselves in front of a judge and opposed to a prosecutor. My endorsements, because of my appellate experience and my broad experience, my legal experience, are equally broad. So, in addition to Governor Ferguson and Gregoire, I have 8 of the 9 current Supreme Court justices. I have the mayors of Olympia, Tacoma, and well, actually, there are quite a few mayors, and I won't go through the whole list. Probably 20 state senators and about 32 state representatives. And I should just say at the end, the 36th is my home, so I'd be honored to have your endorsement.
Thank you so much. Now we have the prepared questions from our membership, and Joanna will ask the first one.
How would you approach cases asking to overturn longstanding judicial precedent, especially for cases that were decided long ago when Washington State looked differently than it does now?
So it's a great question, and it's a difficult question. The test that we use in the law for determining whether to overturn a case is very simple. Was the case wrongly decided, and is it harmful? So that's the basic test. But behind that basic test are some really important issues. And I have to confess that I feel a little bit differently about this issue in the wake of the Dobbs decision from the US Supreme Court than I did beforehand. The US Supreme Court simply changed membership and decided that it no longer wanted to recognize reproductive rights. So those kinds of decisions haunt me as a judge, and they make me think about precedent in a very critical way. So when we look at whether a decision is wrong, is it incorrect, we ask ourselves a lot of other questions like, have people relied on this decision over time? And if so, how? Have people criticized this decision, and in what circumstances? Are the other cases that the case cited to reach the decision that we're thinking about, have those been overruled, or have they been undercut in some important way? And has the fundamental basis for the decision changed? In other words, was the decision issued at a time when the concerns were very different, and the issues that motivated the court at the time and the issues the court was trying to understand and solve, were they very different? But it's really critical for a justice to work extremely hard when thinking about these issues. We need to go back to the framing of our state constitution in the 1800s and through to whatever the amendment is that's at issue, and really understand what was motivating the amendment, what was the purpose, and how does it fit within our separation of powers now? How do we ensure that our government is operating as it's supposed to under our Constitution, while respecting precedent? But sometimes we just get it wrong as judges, and we have to admit that and move forward.
Thank you. Our second question is coming from Anita.
Artificial intelligence or AI is not always a well-defined and understood term. How do you define AI, and how do you think the court should approach using AI in day-to-day operations?
Great question. So let me start with the first part just quickly. AI really has to do with any set of programs or algorithms where machines can learn from the data that are provided and provide an output based on that learning. They're sort of organic algorithms that can change over time. And so, how should courts use this? This is something I'm spending a lot of time thinking about right now. I'm going to be the incoming chair of the Judicial Information Systems Committee. This is the committee that governs the entire computer system and how we track and keep records and how we operate electronically as a set of courts throughout the state. So it's very critical that we get this right. AI is a very powerful tool, and here's how I want to use it. Right now, civil justice in particular is unfortunately a luxury good. A lot of people are simply priced out of being able to use the courts to obtain real justice and to obtain redress. And so AI is a way that I want to use to allow individuals in cases like family law, where people often can't afford to do what they need to do, and in injury cases or violation of rights to put together their papers, to tell their story essentially to the programs and put their papers together in a way that allows the courts to rule favorably. What AI can never do is replace the act of human judging. Judges are the ones who can understand the human dimension of what we do, understand the implications of what we do, and reach the result that genuinely enhances justice. And machines just cannot do that. And we need to safeguard keeping them out of the courtroom and out of the judging process, but use them to help people actually get a genuine day in court.
Thank you for that nuance between the tech tool and the human side. Our third question is coming from Howard.
Hi. The Harvard Crimson recently reported on an emerging two-track clerkship system aligned on ideological grounds with distinctly different paths for liberal clerks versus conservative federal judges. How does ideological alignment impact the work of a judge, and how can we create and protect a nonpartisan bench? Since electing judges is an inherently political endeavor, how do we ensure that judicial races do not become de facto partisan?
Great questions. And this is a trend that's been going on for at least 30 years. It's something I lived through as a law clerk, and I saw how this worked. But I was lucky enough to be selected by, in my case, a conservative judge who wanted to surround himself with someone whose views were much different than his own. And I've really taken that to heart in how I approach the situation. So I do two things. One of them is a little bit unusual, but it really works for me. For every case that I have, I make a list of all of the potential biases that could be influencing my decision. So first thing I do is I write out in bullet points what my emotional reactions were to the arguments that were presented. And then I identify all the ways in which I'm linked to the issues, the parties, and the general circumstances of the case so that I can try to identify and name. And so social science teaches us that when we identify biases, we do a much better job of overcoming them and removing them from our decision-making process. And I asked my law clerks to do the same thing. I'm already hiring my first set of law clerks now, and I'm also looking for people who believe differently than I do and have different life experiences than I do, because it makes for a better and more well-rounded set of decisions. And it's frankly, it's the same reason why diversity, equity, and inclusion initiatives are so important. We want to make sure we have people around us who have different life experiences. As for the question of judicial elections and how we stop the politicization of our courts, on the one hand, it's a real blessing to be able to walk around every neighborhood in the state and talk to voters about their experience with the justice system. Hearing that directly is critical to doing a better job, and that's one reason why I have my email address on the court website. I want to hear from people on what they're doing. But we have to be ready to lose for a sense of justice. And most of the great justices I know feel that way. And that's how I feel as well. So being a judge is the number one job. Politics comes second.
Thank you for introducing all of that and leading us to our last question, our last prepared question. Tell us a little bit about the continuing education requirement for judges, and how do you proactively seek out furthering your knowledge and understanding of bias, diversity, inclusion, and accessibility? And how have you applied these to your work?
Another great question. Thank you. So, judges do have continuing judicial education requirements, and they're a lot like the requirements that are in other fields, for practicing lawyers and for medical fields. All of us have mandatory professional education. And the reason we do that is that we can grow a little stale in our knowledge. One of the most important things we do as judges is to identify and check our biases. I already talked a little bit about one way that I do that, but I just attended the Appellate Judges Conference in March at the Supreme Court, and all of the appellate judges in the state were there. And we spent over half the time talking about different facets of bias: racial bias, language bias, gender bias, and then biases that are intersected among those groups. So I'm not sure if you're familiar with the Gender and Justice Commission. This is one of our commissions on the Supreme Court, and it periodically issues kind of path-breaking reports about reforms that are needed and what we can do to actually make our justice system more accessible. The most recent report is 900 pages, and I am working through it and have been for a while, but it talks about the ways in which race and gender combine, along with some of the burdens that we as judges have imposed on individuals that make it hard for them to access justice. So what I am trying to do, both with my judicial education requirements and the administrative work that we do as justices, is to really target two or three of these critical problems and make genuine progress on them. One of them is removing financial barriers. So one of the reasons we have juries that are not diverse is that we don't allow childcare in our courthouses. We don't have pay that is adequate to actually allow people to come to courthouse. And we have immigration agents sometimes swarming the courthouses, making it difficult for people to come around. So I'm working on those particular issues. And I'm at the same time working on technology solutions of the type I talked about, which are designed to allow people to put their case in front of a judge in the right way using technological tools.
Thank you. So now we have a little bit of time for some follow-up questions, and you will have a minute to respond to each of those. And I see Howard's hand first. Thank you, Howard.
Hi. So just expanding on that last point, in 2020, the Washington Supreme Court really made a stunning statement concerning racial justice, inequity, and racial inequity in the justice system. So I'm just wondering if you can expand a little on that, if that's something that you would support and expand on, because we haven't heard a lot since 2020. So
Yeah, it's a great question. Thank you, Howard. So that was a fundamental and important part of what our court did. Um, that letter was groundbreaking and was truly wonderful. It came in the wake of some horrific abuses directed primarily to African American men who were, on the streets and were brutally murdered there by law enforcement. So let me tell you what's been happening behind the scenes and what I'm so eager to plug into, because our justice system is really a reflection of some systematic racism that exists in our society. Unfortunately, we're trying to overcome implicit and explicit bias that's still there. So we have a new standard that we use in every case, civil and criminal, called the Objective Observer Standard, that we're using to try to root out all discrimination that could impact verdicts and regular hearings in all of our courts. It's new, it's controversial. Justice Alito is trying to undo it, but it's a key part of what our court is doing to build on the legacy of that letter behind the scenes.
Thank you. I had a question. You mentioned when you were talking about overturning longstanding judicial precedents. And you mentioned Dobbs and how the changing membership of the court may have affected that decision. Can you say more about that?
Absolutely. So it's very clear that there has been Leonard Leo, the Federalist Society, there was an effort to deny Democratic presidents their appointments and ensure that Republican presidents had their appointments. And in doing so, one of the primary reasons for doing that was to get a court majority in place to overturn Roe v. Wade, despite the fact that we had generations of women and men, frankly, who relied upon Roe v. Wade as a cornerstone of reproductive rights. Now, it really strikes at the heart of our justice system when people look and understand that the only reason why something has changed is because the makeup of the court has changed. So when an opinion is struck down, especially a longstanding one, it really is critical for the courts to explain in great detail why that was done and to do so in a convincing way. The Dobbs decision is a travesty. I don't know if you've had a chance to actually read it, but it is so transparent and superficial that it's created, a generation of worth of problems.
If no one else has a question, I do have another follow-up, but we have Sarah Renneveld coming in. Go ahead, Sarah.
Hi, I just had a question, a follow-up on just the use of AI. I agree that it's complex and has potential. But of course, even in the family law context, I think, as an attorney, obviously I have concerns that folks that are particularly pro se could use it and are held to the same standard, without sort of like checks and balances. So how can you say just a little bit more about how you see it being a useful tool, like in the family law instance in which you were referencing, and more generally with pro se's or others litigants that are trying to access justice?
Yeah, absolutely. Absolutely, Sarah. It's a great question. And this tension is one of the fundamental reasons why our limited legal technicians program has been so difficult and sort of has foundered over time, because finding the right balance between protecting individuals and helping pro se individuals actually achieve justice is very difficult. And so we're going to have backstops. But as you know, family law is a forms-driven practice for a significant portion of it. There are key judging issues about relocation, for example, or about termination of parental rights that will never be AI based. But when it comes to filling out complex forms that ask for income, that ask for assets, that ask for allocation of time for parenting plans, holidays, those sorts of things. These trip up a lot of pro se litigants, and AI does an excellent job of helping litigants fill out the forms that are designed to be easy, but in practice shut the door to a lot of important litigants and a lot of important issues for those litigants.
Thank
Thank
you. And I think we have just enough time for you to offer a 90-second close.
Well, thank you all. I really appreciate your taking the time. I recognize many of your names. I've voted for some of you on this list before, and I really appreciate your service to the 36th. This is going to be an interesting set of elections. We have 5 Supreme Court justice races on the state ballot this year, which we think is unprecedented in history. And in my race in particular, in position 5, we have some candidates there that are, at least one candidate, I'm not going to cast aspersions, is mouthing a lot of values that actions have not borne out in the past. And so it's more important than ever for our LDs to talk to the candidates, really drill down and understand where they're coming from and what really motivates them and where they've been with their record. So I appreciate your taking the time to do that. And I appreciate this process of democracy. Speaking to voters about what we do is half of what's important, but getting honest and genuine feedback is the other part. So I encourage you to please send me your thoughts. Again, you can find my email address on the court website about how we can improve our justice system. And I'd love for you to send it out to the members, because we take that all very seriously. Ultimately, our justice system is always about the people that we serve and how our rulings actually impact them. That's what I've done throughout my career. That's what I think really will make a difference. and I would truly and genuinely appreciate your support.
Thank you so much. That is our time with Justice Theo Angelis, candidate for Washington State Supreme Court, position 5. Thank you so much.